2nd, 2022 to order. And let's start with a roll call for attendance.
Thank you. Commissioner Kelly?
Here.
Commissioner Fernandez?
Here.
Commissioner Dauch?
Here.
Commissioner Burns?
Here.
Vice Chair Ottinger?
Here.
And Chair Fritz?
Here.
Excellent. We have a full complement tonight.
Great. I will read my Zoom script. This meeting is being conducted utilizing teleconferencing and electronic means consistent with state of California executive orders regarding the COVID-19 pandemic. Zoom is being utilized for this meeting. In case of technical issues, meetings will be uploaded to the city website as soon as possible after this meeting. We will be conducting today's meeting in a virtual setting using Zoom. Planning commissioners and staff are participating from remote locations, practicing appropriate social distancing. Members of the public may view and listen to the meeting by use of Zoom as noted on the city's website and is noted on the agenda. Members of the public wishing to speak to the Planning Commission may do so during public comment or may comment on agenda items during the discussion of each item and must be logged into Zoom. Anyone using abusive, vulgar, offensive, threatening, or harassing language, personal attacks of any kind, or offensive terms that target specific individuals or groups will be muted and removed from the meeting. Please do not abuse this new way to provide public comment. All right, moving on. We have no minutes to approve. And seeing as we have no members of the public, I think we can skip the public comment from items not on the agenda.
Yeah, I will note we have not received any public comments for the commission on items not on the agenda. So nothing there.
And I'm assuming we have no conflicts of interest since we don't really have anything that we're discussing tonight.
I hope not, because it's the ethics.
And yeah, I guess we can get started.
Okay. And this might take me just a moment. I think I need to remember how to do the computer audio. So if you can't hear this, let me know and I'll stop it for a sec and redo that.
101. We will look at how ethics govern a planning official's duties and responsibilities. Everyone has a
We can hear, but we can't
conflict
see.
of interest or an ethical dilemma. Suppose you're a planning official and the local hospital is up.
Can you hear and see?
Yes.
Excellent.
I can't hear very well, no.
Here.
Let's see if- Let me pause it for a second and see if there's a setting for the sound coming through. Hold on. Is it just very quiet for you guys?
Yes.
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 Okay,
Yeah,
because
it's
it's kind
kind
of
of
quiet
quiet,
for me
garbled.
too. So let me see if I have.
I noticed we have a new instructor this week.
Yes.
Okay, I'm going to try this again, just with my computer sound instead of my normal speaker sound.
Career helps illustrate what can occur regarding
No.
employment in hospitals.
Now, I'm guessing you guys can't hear it because I can't hear it either.
Nope.
Let me just start this completely over. Sorry.
There was something specific you did last time. Obviously I don't know what you did, but I remember because it didn't work last time and there was some setting.
It should be a share with computer audio or share computer audio in the share options.
Okay, supposedly this is the high fidelity. So let's hope this works. Can you hear?
Nothing.
Okay, I can't hear anything either. Audio settings.
Occur regarding ethical dilemmas.
There you go.
Oh, there we go.
Another example is a planning commissioner having a lunch with an applicant that is going to be going before
Anything?
the planning board.
Yep.
Yeah, that
in
works.
days.
That works.
These all present potential conflict of interest and ethical dilemmas. A personal example that occurred early in my professional career helps illustrate what can occur regarding ethical dilemmas and conflict of interest regarding appointed officials. I was asked by a senior planner at my firm to attend a planning commission meeting in his absence to help answer any questions that might come up during the development review portion of the agenda. About halfway through the planning commission meeting, an item came up on the agenda regarding an expansion of a local business in this small town. One of the planning commission members excused himself and moved to the podium to represent the applicant as the architect for the expansion of the project. He proceeded to explain the expansion of the business and how it met the requirements of the ordinance. Something didn't seem right to me in this situation. Immediately I began to question whether this was a proper practice. The planning commission and planning commission member went on as if this had occurred as common practice. The planning commission member was wearing the hat as the applicant's architect before the planning commission, while also serving in an official capacity for other business of the planning commission during the same agenda. Now just imagine the real and perceived conflicts of interest that may exist in this situation. Even though the planning commission member was not voting on this item, what influence was he having over his fellow planning commission members in this situation? Should he even have been in the room, knowing he was representing a client applicant before the planning commission? And what duties and responsibilities did he have to the planning commission in this situation? How does state ethics law address similar situations? And what ethical principles of planning were violated, if any? Hopefully this course will help you better recognize ethical issues that may arise from time to time as a planning official and how you can either avoid or address these situations with further confidence. By the end of this course, you should be able to define ethics and define the role of conflict of interest, identify the relationship between ethics and conflict of interest, identify how ethics affect your duties and responsibilities as a planning official, identify additional legal principles that affect your job, and identify ethical principles of planning. I hope you look forward to it. Now let's get started. When most people hear the word ethics, they think of people's actions and whether those actions are right or wrong. A dictionary definition of ethics is a system of moral principles governing the appropriate conduct of an individual or group. The appropriate conduct of a planning official has been described in many ways. In a nutshell, ethical conduct by planning officials really boils down to three concepts. 1, conflict of interest, 2, incompatible office, and 3, appearance of impropriety. These concerns encompass a list of behaviors that may create ethical dilemmas for planning officials. We've all been to a public meeting where emotions run high and there is a lot of attention on that planning official. What we want to make sure is that we're minimizing those opportunities where ethical concerns play into the overall decision-making for the planning official. One key issue is preferential treatment for an applicant. Let's discuss how preferential treatment could be perceived and play out in a public meeting. At times, local land use decisions are discussed and debated during highly contested public hearings, sometimes dealing with activities referred to as locally unwanted land uses, or LULUs. These are often large projects with environmental concerns. Tensions were already behind these situations. If the project involves a large company, Citizens may already feel the process is rigged and the community will not be fairly treated. The public's perception of bias among planning officials and their preferential treatment for the applicant will likely already be present going into this meeting. How the planning officials conduct themselves will be closely scrutinized. For example, one official whispering to another official during the public hearing, even if it's about something other than the application at hand, may be perceived as sharing inside information or commenting on details not available to the public. The goal is to minimize these appearances so as not to distract from the public process. Remember, private agendas must fall to the wayside in favor of acting in the best interest of the community. In a nutshell, a public office is to be used to serve the public good. While the parties who bring their cases before the community have a right to protect their private interests, public officials have a responsibility to represent the public good. But what does representing the public good mean? A planning official must have special concern for the long-range consequences of present actions and pay special attention to the interrelatedness of their decisions.
So what are standard responsibilities on how public officials should conduct themselves in public? How are planning officials and their actions viewed by the public? What is the code of ethics for a planning official?
These are three important questions to ask to help recognize, evaluate, and address ethical dilemmas as they arise. If needed, officials can ask for the assistance of their fellow elected or appointed members to help determine how to deal with an ethical problem. They may also wish to consult the community's planning staff, bylaws, and legal counsel early in the process. Indecision or failure to act appropriately fuels distrust of local government and places the official in a no-win situation. It's helpful to keep in mind in each stage of the planning process that public officials are not acting as individuals, but as part of a group, the members of which have willfully given up a small portion of their individual rights. As the government, public officials are charged with the task of protecting other citizens' rights as well. This comes with an obligation to know and follow the statutes, court cases, procedures, and local ordinances pertinent to the office. This may be a good time to acknowledge, as the American Planning Association has noted, that ethical principles derive both from the general values of society and from the planning official's special responsibility to serve the public interest. As the basic values of society are often in competition with each other, so do these principles sometimes compete. Also of note is the distinction between morals and ethics, although they are related. Morality is personal and in many cases private, while ethics is professional and public within the local planning context.
This quote by Justice Potter Stewart really outlines what it is that we're trying to address when we talk about ethics and conflict of interest. What you have the right to do does not equal what is right to do. What do we mean by this? There are laws that affect how planning officials conduct themselves in office. Planning officials must hold themselves to a higher standard because they are public officials, not simply citizens of the community in their new roles. What is a conflict of interest? Let's take a look at what a conflict is and what a conflict of interest is, and so that we have a better understanding of both. Conflict is a difference, a disagreement, or a clash between ideas, principles, or people. In the context of municipal government, a conflict of interest occurs when an individual has multiple interests, any one of which could corrupt the overall public process. An example is useful here to demonstrate. Let's say I'm the chair of a committee that's going to decide office space within the office, but I also have my eye on a certain corner office space. In this case, I may have a conflict of interest. As a committee chair, my job is to be fair and follow a set of rules. But privately, I may have my interest on that corner office, which again could corrupt the overall process. If you're a planning official, an example of a conflict of interest may be if there's a development proposal within your neighborhood that you may have some interest or stake in. That's an example of where there could be a potential conflict of interest.
Keep in mind that it's reasonable to have personal opinions about development proposals and acquaintances that come before your local board. The key question to ask is whether there is a real or perceived conflict of interest in each of these situations. Let's take a look at a hypothetical scenario and see what possible conflicts of interest exist and how to recognize them. Rick is in the sand and gravel business and proposes to open a new 40-acre mine just north of town in an area zoned agriculture. This is one of the few remaining places in town where there's good gravel, says Rick. The site is currently farmed, but the farmer is ready to retire and sell the land for his retirement income. Rick is applying for a special use permit so that his gravel mine can be built. As is typical for this type of development, the proposal is highly controversial. Tom, Kathy, and Harvey are Planning Commission members. Tom lived with Rick in the dorms when they were a freshman in college. While in school, Tom studied criminal justice and Rick earned a degree in construction management. Although they haven't kept in touch for years, they run into one another at church on Sundays. Tom's brother Billy is in the septic business and buys gravel from one of Rick's other gravel mines in the adjoining community. Kathy lives in a neighborhood close to the proposed mine. Although she hasn't said anything to her fellow planning commissioners, she's wondering whether dust and noise generated from the mine would affect the value of her house. Harvey, Rick's cousin, holds a 40% share in one of Rick's other businesses, a profitable excavating firm. Harvey is not involved in the day-to-day management of the company. Tom, Kathy, and Harvey all have some relationship to the proposed plan or the applicant. Who do you think has a conflict of interest, and why? Let's look at Tom, Kathy, and Harvey one at a time. Regarding Tom, he lived with Rick in the dorms in college. They haven't kept in touch with each other for years, but they do run into each other once in a while at church on Sundays. These facts probably represent minimal contact, but perception is still there. However, the fact that Tom's brother Billy is in the septic system business and buys gravel from one of Rick's other gravel mines in the adjoining community is perhaps more problematic. There is a family member with a financial interest that could be impacted by the outcome of the Planning Commission decision. This creates a more direct financial interest, although there is nothing in the facts that suggests that Tom will benefit personally. Now let's look at Kathy. She lives in a neighborhood close to the proposed mine. She is wondering whether dust and noise generated from the mine would affect the value of her house, but she hasn't said anything to her fellow planning commissioners. This is really a question of whether Kathy can objectively review the proposal based on the merits of the application without her self-interest filtering into her decision. The mine is not actually proposed in her neighborhood, so she is not within the direct sphere of influence based on the facts, but she has concerns for impacts on her house. Concerning Harvey, he is Rick's cousin and holds a 40% share in one of Rick's other businesses, a profitable excavating firm. But Harvey is not involved in the day-to-day management of the company. However, Harvey's conflicts should be more obvious at this point. There is a family relationship and a direct financial interest in one of the applicant's other businesses. While some may argue it's not the business under review, the tangled financial interests are too close to ignore coupled with the family ties. Clearly, Harvey has a conflict of interest in this situation. Should they declare their relationships at the start of the public hearing? This will depend partially on local bylaws and state guidelines and statutes for disclosing conflicts of interest. Ideally, some of these disclosures should occur before the meeting to discuss with staff and get a legal opinion if necessary. In short, if there is a real conflict of interest, or if a planning official determines they cannot act impartial towards the applicant or proposal, they should take steps to remove themselves from the hearing. So if they have a conflict of interest, should they A, not vote, B, not participate in the discussion, C, sit with the audience and comment as a private citizen, or D, leave the room during discussion of this issue? This may be a different answer for Tom, Kathy, and Harvey. Concerning answers A and B, not vote or not participate in the discussion, if a conflict of interest has been determined, not voting or participating in the discussion is an appropriate action for the planning official. Answer C, sit with the audience and comment as a private citizen, is not a preferred option for a planning official when an agenda item is before their own board. Yes, not voting or deliberating on the agenda item in an official capacity is the prudent thing to do, but still commenting as a private citizen can be perceived as providing undue influence over the body you have been appointed to serve on. Answer D, leave the room during discussion of this issue, is an appropriate tactic if a personal or financial conflict of interest exists. These are difficult questions to tackle, yet addressing ethical conflicts of interest before the hearing is the appropriate thing to do.
You may have a conflict of interest generally whenever the issue involves your own personal finances or involves a family member or a relative. Other examples are if the project is nearby, a decision that's affecting your employer or an employee, or some other type of financial situation that is involved with the decision-making process. Keep in mind that states have guidelines and laws that constitute a conflict of interest. It's important to check with your municipal attorney to find out exactly which laws and guidelines affect you as a planning official. Welcome to Chapter 4, Potential Conflicts or Appearance of Impropriety. Related to conflicts is the issue of the appearance of impropriety. This concept may be defined as the appearance of a conflict of interest, although one may not necessarily exist. An illustrative example of this is a case from New Jersey. In the case of Gunther versus Planning Board of Borough of Bay Head, a 2000 case, 7 members of the planning board were also members of a private yacht club. The yacht club was actually before the planning board with a proposal for a development project. The owner of the adjacent marina proposed to develop a subdivision. While there was no proof that the board members were not impartial, and in fact they claimed that they could judge fairly, the court nonetheless held that the 7 yacht club members on the planning board had a potential conflict that could taint their decision-making.
So how do you address these issues as they arise? If you have friends or business associates related to items before your board, it's a good idea to discuss these situations beforehand. Let's take a look at a hypothetical scenario to see how these issues could play out in a particular situation. There is an older neighborhood in town with many large homes with porches. In the 1960s and 70s, the area declined and a substantial number of houses fell into disrepair. In the past 10 years, though, the historic charm of the neighborhood has made it an attractive area and many of the homes have been renovated. It's the place to be for upwardly mobile professionals. Sue and Robert, 30-something attorneys with 3 young children, moved to the area and recently purchased a smallish craftsman-style house in the neighborhood that had been badly neglected by the previous owner. The couple intend to tear down the house and build a substantially larger modern-style home on the lot. They submitted an application to the town zoning board of appeals requesting a variance to encroach on the side yard setback and exceed the height limitations by building a 3rd floor. In their application, they state that the variances are necessary to construct a home large enough for their family and with comparable square footage to the other homes in the neighborhood. Renee, Ruth, and Jim are ZBA members. Renee is an administrative assistant at the architectural firm designing the couple's new home. Jim lives next door to the lot in question. For years, he's complained about the old place and called the police on several occasions because of loud parties hosted by the renters. He is delighted that the place is finally being fixed up and the crummy old home demolished. Ruth is absolutely incensed by the whole idea. She's past president of the Historical Society and is angry about the plans to demolish the house, one of the few remaining craftsman-style homes in town. Her great-aunt used to live in that house. Ruth tried to buy the property a few years ago, but couldn't afford the high asking price. Renee, Ruth, and Jim all have some relationship to the proposed plan. Who do you think has a conflict of interest and why? Let's take a look at each of the ZBA members one at a time. Renee, possibly a conflict of interest, since her employer stands to receive a financial benefit if the variance is approved. It is a question of fact and local guidelines or state laws whether just being an employee of a company associated with the project, but not the applicant, is a close enough tie to definitely be considered a conflict of interest in every situation. It would clearly be a conflict of interest if one's continuation of employment was dependent on the outcome of the application review. It could be a different story if the employee's position is far removed from the request at hand. Even if Renee doesn't technically have a conflict of interest, remember, it's important to avoid even the perception of one. Note, however, that there are some communities where many residents are employed by or have a link to the area's one major employer. If a strict conflict of interest definition included from decision-making all residents with a tie to those companies, it might be tough to assemble a quorum to make virtually any planning and zoning decisions. Jim, definitely a conflict of interest. Being an adjoining property owner to the project site almost always constitutes conflict of interest. As he stated, Jim has a lot to gain personally by removing the old structures. Ruth, probably not a conflict of interest. She definitely has an opinion about the property and removing the old house, but her views alone do not constitute a conflict of interest. It's important to ask yourself when these situations arise. Is there a legal conflict under local or state laws? Can you act fairly or impartially? And how would the situation be perceived by the general public?
Welcome to Chapter 5, Ethics and Conflict of Interest. What does ethics have to do with conflict of interest? Like Michigan and New Jersey, Connecticut also has a provision of state law that specifically addresses conflict of interest by planning officials. The last sentence in this statement is really the most critical, and that's that no planning board member should vote on a decision in which he knowingly has a pecuniary interest. So there is a difference between conflict of interest and ethics. Ethics addresses when and how the conflict of interest exists. A tip from a local expert is a good example here to illustrate the point. Dr. Mary Ann Heidemann, who's a professional planner and has also served on local boards and bodies in Michigan, explained a story where when she was new to a local community, had recently moved there, she was asked by the mayor to serve on the Zoning Board of Appeals. She explained that her views about local decisions may be different than other members of the board, particularly because she was a professional planner. But the mayor responded, in essence, well, Mary Ann, since you're new to the community, you don't have any family and friends living here. So the part that is important to understand in these situations is that it's not practical to have a planning official member perhaps that has no family and friends in the community. That's not what we're trying to get at here. Although recognizing, as Mary Ann pointed out in this example, that it becomes difficult when we have decisions that affect the community and our neighbors and perhaps family members that are affected by these decisions. This is a very challenging task for planning officials, particularly when you have your neighbors and friends attend the meetings that may be contrary interests to the community in moving forward. An example to illustrate this point is an article written by John Donahue, a municipal attorney who represented a number of municipalities in Michigan, and an article he wrote, Conflict of Interest, a Personal View. And his quote, "You can't remove yourself from everything under the sun." So yes, there's going to be conflicts of interest perhaps that would be identified, yet you cannot, under every circumstance, remove yourself. So one of his quotes in the article, which I find is telling, is planning commissioners must be prepared to refute the challenge of a disappointed applicant or squarely face the sullen stare of a disgruntled neighbor. An example is under Michigan law, a law that addresses standard of conduct for public officials. In essence, the law covers a few key details around conflict of interest. One, do not divulge confidential information. 2, do not represent personal opinions as that of an agency. Use resources lawfully and judiciously. Do not accept gifts, loans, money, goods, or services that might influence your duties. And do not engage in business transactions or profits as a result of your official position. In general, everything where there's a potential personal or financial interest in the decision should be disclosed as part of the conflict of interest discussion. So can a behavior in one community be ethical and then be unethical in another community? The short answer is yes. It depends on how the community has defined conflict of interest and ethics. It may have different bylaws. Now, of course, if state statute is very clear as to what an issue in one community, if it's the same in another community. But what we're talking about here is there's different circumstances. Maybe one community has a large employer, or one community is large and another is small. There might be some differences among those communities on how they define conflicts of interest in their bylaws. A couple of quotes here that may help illustrate the point. "The time is always right to do what is right," by Martin Luther King. And the basis of effective government is public confidence, and that confidence is endangered when ethical standards falter or appear to falter. John F. Kennedy.
Planning officials should be striving for meaningful and open dialogue, conscious of the rights of others, while providing opportunities for the voices of all citizens to be heard regarding the development of their community. The public deserves the ethical and competent service of its public officials, and planning commissioners can go a long way to help foster and instill that trust. As President Abraham Lincoln said regarding ethics, "It has been my experience that folks who have no vices have very few virtues." It's helpful for planning officials to ask themselves from time to time about who they are appointed to serve and the methods they use in all aspects of their role to instill the public's trust and deal fairly with all participants.
Welcome to Chapter 6, Ethical Actions. To perform his or her duties effectively, a planning official must be able to identify and evaluate the situation, identify the ethical circumstance, and take the appropriate action to reconcile the potential conflict of interest.
Let's take a closer look at examples of how we can identify and evaluate the situation and the ethical circumstances that may exist. We have already discussed the major categories that provide the most obvious situations where ethical dilemmas may arise, including circumstances in which there is a direct financial benefit from the development proposal or a personal interest, such as being next door to the development project. In many cases, it may not be as obvious as these examples. Personal or financial interests evolve over time during different stages of the planning process, particularly for projects that may involve several components such as a rezoning, variance request, and site plan review. For example, we've discussed possibilities where there is a direct personal or financial gain to the planning official. But what about other family members or persons living in the household? How close does a family member have to be to you and the situation to be considered a conflict of interest? There are varying degrees of influence, and local or state ethics guidelines help clarify these situations, but every situation is unique. The planning official should constantly be asking, how would this objectively be received by the public, even if it's thought the family member is far enough removed from the decision at hand. If a spouse, sibling, or child works for the architectural firm, engineering firm, or accounting firm hired by the developer, does that alone create a conflict of interest? What about a distant cousin you have not seen or talked to in years? These are examples of an appearance of a conflict of interest that can become as important as an actual conflict itself. Another tricky area is around gifts. Certainly, planning officials should not directly or indirectly solicit any gift or accept any gift if it was intended to influence them within their official duties or the gift was received for their official public action. Gifts can be broadly defined as entertainment, services, travel, loans, or money, for example. The key concept here is to focus on circumstances of improper influence. The local circumstances, customs, and policies should help guide these situations. However, adopting ethical bylaws and reviewing them annually is an important step for any planning body charged with the public interest in mind. There is also implied ethical conduct, perhaps more ambiguous, such as providing full, clear, and accurate information on planning issues to citizens and other governmental decision makers. Planning officials must make efforts to ensure public studies and planning documents can be accurately interpreted and understood by the public. Sometimes these principles compete with one another, such as situations where information must necessarily be kept confidential based on state and local guidelines and laws. Overall, the planning official should aspire not just for meeting the minimum standards of ethical behavior, but aspirational standards as well that serve to promote positive public discourse for the planning process in general.
So what qualifies as an appropriate action if a conflict of interest or potential conflict of interest exists? This may require the planning official to acknowledge and talk with another planning official whether a conflict of interest exists, talk with the chair, and disclose this during the meeting. Or it may involve a vote of the board to decide whether in fact a conflict of interest exists. So this is actually discussed during the public forum. Welcome to Chapter 7, Legislating Planning Official Conduct. How states address ethical conduct and conflict of interest varies from state to state. Let's take a look at a few examples. Some states, like Alabama, include municipal public officials and employees in the pool of individuals subject to the state ethics code. In these states, administration and enforcement of ethical conduct is overseen solely by the state. Other states have laws that apply specifically to municipal officials. For example, in New Jersey, municipal officials are held to the local government ethics law. In other states, like Connecticut, municipalities establish their own ethics codes of conduct. Some states have adapted provisions that apply specifically to planning commissions and zoning board of appeals members. For example, the Michigan Zoning Enabling Act specifically states, a member shall disqualify himself or herself from a vote in which the member has a conflict of interest. Failure to disqualify a member that fits this definition would be a misconduct in office. Similarly, in New Jersey, a provision of that state's municipal land use law prohibits a planning board member from acting on any matter in which member has, either directly or indirectly, any personal or financial interest. Because ethical conduct and conflict of interest vary from state to state, it's important to understand how your state provisions address these important concerns.
Since we are discussing legislating planning official conduct, perhaps this is an appropriate time to distinguish between law and ethics. The fact that an action is legally permissible does not establish that it is ethically acceptable. An activity or action may technically be legal, yet professional ethics standards go beyond the letter of the law and provide professional norms that not only determine bad things that should be avoided, but also good things that should be pursued. Examples of these ethical principles include social justice to expand choice and opportunity, or planning for the needs of the disadvantaged, and to promote racial and economic integration. These are standards that are difficult to legislate, yet planning officials should strive to act in accordance with these principles, along with their obligation to the public interest. Codes of conduct are not necessarily about dictating planning official morals, which are based on personal beliefs, but rather ethics that are professional and public standards appropriate for a democratic form of public deliberation and decision-making. These are, on the one hand, simple concepts that many of us learned at a very young age, yet they are exceedingly difficult to practice, sometimes with the competing interests we face every day as public officials and members of our community.
Welcome to Chapter 8, Ethics and Fairness. One example is ex parte contact. Ex parte contact can be defined as done for the benefit of one party only without notice to other parties. An important job for the planning official is to be fair and impartial and not prejudge cases. This also means that there needs to be a public forum in which the planning commissioners deliberate and the public is able to hear the deliberation taking place. Like a courtroom, everyone participating has a right to hear all the information. When members of the board talk outside of the meeting, not everyone from the public or the other planning officials have an opportunity to hear what is being said. This is referred to as ex parte communication. Think of this as similar to a jury trial in which information is gathered by the jury outside of the court. This would not be fair to the opposing counsel and the other side. So this is an example of why all the deliberation would need to take place in public at one hearing. Another issue is voting twice on the same issue or application. Think of an example in some states where a planning official can serve on the Planning Commission and also on the Zoning Board of Appeals. If the case was heard before the Planning Commission and then went to the Zoning Board of Appeals, this in essence would be one member voting twice on the same issue. Several states have different provisions or Attorney General's opinion which clarify how to address this issue, but each community should have its own set of bylaws which address what should happen in this particular situation. The important point is for elected and appointed officials to discuss these situations ahead of time and identify a process that will be followed in case the issue arises. The important point is that public officials talk about this kind of issue and decide ahead of time how they will handle this particular situation. Finally, all 50 states have adopted some form of Open Meetings Act or sunshine laws which address how public forums should take place. While there are some exceptions to these laws, such as for privacy and proprietary information, these laws are established so that it's understood how information should be conducted in public and what information should be available to the public. Planning commissioners and Zoning Board of Appeals members are subject to these provisions in their respective states. This is to ensure to the public that no backroom dealings are taking place and the information and the deliberation taking place is all the information available to the applicant and to the citizens. Ex parte contact by a planning commissioner was addressed by an Oregon court. In the case of Fasano versus Board of County Commissioners of Washington County, the parties at the hearing before the county governing body are entitled to an opportunity to be heard, to an opportunity to present and rebut evidence, to a tribunal which is impartial in the material, having had no pre-hearing or ex parte contacts concerning the question, issue, and to a record made and adequate findings executed. Let's look at a reading discussion on this topic titled Ex Parte Communications and Land Use Boards. So what is an ex parte communication? We've already defined that, at least under the Latin term, it means by or for one party. In general, it refers to communication by one board member outside of the meeting with another, an applicant or someone else that is not privy to the full planning commission. So are these types of discussions a problem for land use boards? The short answer is yes. There are four main concerns with ex parte communication. Let's review each of these. The first is the planning board member may have a personal stake or is now biased with the information that they had received that the others did not. This can mean that the board member no longer is a neutral party to this hearing and may disqualify himself or herself from the decision. A second point is if the board member is engaging in conversations outside of the meeting, it can bias their position and mean that they are no longer a neutral party. Another point is that the other board members may feel that this gives that board member an unfair advantage in the decision. And finally, if any board decision has been reached as a result of the ex parte contact, the decision may be subject to legal scrutiny. Here's an ex parte question to ponder. Although we tried to prevent an ex parte contact, an adjacent property owner just sent all of us on the board a long emailed message with lots of attached documents. Some of us have read it, and some of us have not. There is no indication that the applicant received a copy. What do I do now? It may be necessary to completely strike the information from the record or disclose the information to all planning officials so everyone is dealing with an equal playing field. The key to curing the issue is to make sure that that information is disclosed to everyone on the planning board and everyone has adequate time to discuss and go over the information, similar to the ex parte contact that took place prior to the meeting.
A common situation in which ex parte communication can occur is during the site plan review process. Planning commissioners regularly review dozens if not hundreds of development proposals annually as part of their official duties. Many communities encourage planning officials to have familiarity with the site details prior to the hearing on the development proposal. This often involves a site visit by the planning official as part of their regular duties. Consider the following hypothetical scenario to see what possible ex parte communication can take place as part of a site visit for development review. A local commercial developer would like to build a new, locally owned restaurant called Burger Barn with a drive-through window along Center Street, the main corridor in town, which is several blocks from the downtown area. The site was recently rezoned from B1 to B2 commercial to allow for drive-through restaurant establishments. The rezoning received some opposition from the adjacent neighborhood with concerns for increased traffic. A site plan was submitted to the Planning Commission for review, and a special use approval public hearing has been scheduled. The zoning administrator included the site plan with the packet sent to the Planning Commission members the week before their next meeting, giving them time to review the plan and visit the site before the hearing. Harvey, a long-standing member of the Planning Commission, remembers when that whole strip was an open field where he used to play as a kid. He recalls the dirt baseball diamond he and his buddies made on the corner where the new restaurant is to be located. Home plate was right near the old oak tree they are cutting down for the driveway, says Harvey. One afternoon, he was driving by the site a few days before the Planning Commission meeting on his way to complete an errand, and he noticed some surveyors on the property. There had been a rainstorm the night before, and Harvey noticed a large portion of the site was flooded, just as he remembered it as a kid after big rainstorms. Harvey decided to stop and do a quick site visit to find out more about what was going on. He walked up to the surveyors and mentioned he was visiting the site as part of his official Planning Commission duties, since the Burger Barn was on the Planning Commission agenda next Monday night. Harvey asked them, "What are you planning to do about all this water on the site?" One of the workers introduced herself as the project engineer and said, "We're working on it now, but this will all be fixed with the new grading plan for the proposed development." A short time later, the developer showed up to meet with the survey crew. Harvey recognized him from a previous project he presented to the Planning Commission last year. The developer introduced himself as Carl and offered to give Harvey a tour of the site. "This is going to be the nicest looking commercial building on the whole corridor with all the beautiful brickwork and landscaping," explained Carl. "We're also going to create 50 new jobs with 8 employees on an average shift to deal with all the vehicles we expect with the best drive-through in town." Harvey explained that he grew up in the neighborhood and said, "It will be sad to see that old oak tree cut down over there where you have the proposed driveway. Anything you can do about that?" As they were talking, a nearby neighbor, Kathy, showed up after recognizing Harvey talking with the developer. "So, how do you plan to keep all the new traffic to this place off our residential streets?" Harvey commented, "I think the developer has a plan for that." Carl jumped in and said, "Well, with 2 proposed driveways, one over there next to the oak tree and the other on Center Street, I don't think that will be a problem." Harvey realized it was getting late and he needed to complete his errand before the store closed and said his goodbyes and left the site. What ex parte communication, if any, occurred in this situation? There are several ex parte communications. Let's take a look at each one. First, Harvey approached the survey and engineering crew and asked them about addressing a site environmental issue regarding the flooded site. While the contact appeared to be minimal, nonetheless, two-way communication occurred along with site details. Next, Harvey had a conversation with the developer. Information was shared about traffic patterns, building materials, and the number of proposed employees on the site. While some or all the information may have already been submitted as part of the site plan review packet, it's not clear at this point, and surely Carl was understandably trying to put the development in its best light, but may have revealed information that was not yet available to the general public. Harvey also asked the developer to address an important site feature, the old oak tree, and how it could be saved. Again, while this is a reasonable request during a public hearing on the site plan, making such requests outside the public realm is generally beyond the role of a planning commissioner and ex parte contact that should be avoided. Finally, a communication occurred with Kathy, a neighborhood resident. Harvey's short remarks and Carl's response could appear to fuel some of the neighborhood concerns that their issues regarding traffic will not be addressed or get a fair hearing. Harvey and Carl's comments and observed communications could give the perception that they have information that is not available to the public. So what should Harvey have done in this situation? Harvey already had in-depth knowledge of the site from growing up in the nearby neighborhood, but gaining a better perspective of the proposed development relative to the site is a reasonable activity as a planning commissioner. However, the site visit should be done within the guidelines established by the community. Planning commissions should establish procedures for individual or group site visits that adhere to their state's Open Meetings Act or similar acts and avoid the real or perceived appearance that they have gained information not available to the public. One concern is to avoid ex parte contacts or communications that occur outside of the official public meeting. It is reasonable and appropriate for Harvey to conduct a site visit based on local guidelines and laws and procedures that are supported by the community's legal counsel. When Harvey drove by and observed workers on the site, he could have continued his personal visit without speaking to the engineer or survey crew, or simply come back at another time. Similarly, Harvey should have respectfully declined the site tour by the developer. Even though this could have been an innocent gesture by Carl, it provided a real possibility that Harvey could be further influenced about the development proposal with information not yet available to the other planning commissioners or public in general. When approached by a resident from the area neighborhood and asked a specific question about traffic, Harvey should have politely explained that the Planning Commission is considering this site plan application at Monday night's meeting and encouraged her to attend, and explained he is not permitted to discuss details on the pending matter before the hearing. Finally, since the ex parte contact has occurred, the best way to remedy the situation is to disclose the details learned and the nature of the discussion that occurred at the next Planning Commission meeting during the hearing on the site plan. While it is prudent to gain as much knowledge about the development proposal before the meeting, planning officials must take steps to avoid communications that otherwise occur within an official public meeting in which all parties hear and can deliberate and act on that information.
Here's a tip from the experts. Kurt Schindler, former MSU Extension senior educator, from an example that he was familiar with in Michigan. There was a community that was proposing a development proposal for a gas station near a freeway. And in this case, a member of the Planning Commission also served on the Zoning Board of Appeals. After the Planning Commission had made their decision, it went to the Zoning Board of Appeals. And the same official was voting on the appeal. It was challenged later and it went to circuit court. And in essence, the judge determined that this was voting on the same issue twice. So back to that issue that we mentioned about voting twice on the same issue, due process. We'll be talking about that in some later courses. But due process, in essence, was violated for the applicant. And in essence, the community had to rehear the appeal all over again. So we want to try to avoid those types of situations and address our procedures and protocol up front so that we can alleviate some of these problems. If the issue was controversial the first time through, just imagine what it's like to rehear the hearing again. Welcome to Chapter 9, APA Ethical Principles in Planning. The American Planning Association has adopted a statement of ethical principles in planning to offer principles and procedures to help engage citizens, planning officials, and practicing planners in negotiating the tough ethical and moral dilemmas they sometimes face. Let's review a few of these key principles. These principles suggest that the public interest is best served if planners, planning officials, and citizens respect citizens' rights to participate, keep citizens informed, and carefully consider the consequences of actions on people, the natural environment, and the built environment. The planning principles are also established so that the public does not lose faith in the planning process. To maintain respect for the planning process, participants should be honest, avoid conflicts of interest, be fair and impartial, use information appropriately, and be prepared and informed. The APA Statement of Ethical Principles in Planning really is a good template for how to be proactive in engaging the public. We've been talking a lot about conflict of interest and ethical principles. Part of the process here is also to be proactive in engaging the public, providing good and concise information, and having the citizens informed about the planning decisions that are taking place. Another important topic covered in the APA principles is a key issue that we've been discussing today: abstain completely from direct or indirect participation as an advisor or decision maker in any matter in which they have a personal interest. Planning process participants should exercise fair, honest, and independent judgment, make public disclosure of all personal interests they may have regarding any decision to be made in the planning process. A couple other key concepts included in the APA principles include not to use confidential information acquired in the course of your duties to further a personal interest, and also not to misrepresent facts or distort information for the purpose of achieving a desired outcome.
While the American Planning Association Code of Ethics is primarily for professional planners, they are a useful tool to provide guidelines for how all public officials can and should conduct themselves regarding their professional responsibilities. The ethics principles are based on the underlying premise that the planning official's primary obligation is to serve the public interest, while high standards are achieved with professional integrity, proficiency, and knowledge. Let's discuss the following hypothetical scenario to review the application of some of these AICP Code of Ethics rules of conduct. Once the town's main employer, White Manufacturing Company, went bankrupt in the early 2000s and has been abandoned since that time. A local investor, Steve, bought the 10-acre property at a tax sale and wants to develop the site. He submitted an application to rezone the area from industrial to general commercial, but no site plans or development applications have been submitted at this time. Steve is friends with Larry, a planning commissioner, and they regularly meet for lunch to catch up on things. During one of their recent lunch meetings, Steve asked Larry for advice on how to proceed with the White Manufacturing project if the rezoning is approved. During their lunch, Steve rolled out a sketch plan drawing of the site. "This is what I want the old White Manufacturing site to look like," he said, pointing to the sketch. "This is going to be a first-class development with apartments, houses, a park, and commercial space. There's even going to be a gazebo for music society concerts." Steve explained he intends to demolish the old buildings, which were poorly constructed eyesores, and clear the site except for the historic brick factory office, at least for now, if he can find a viable use. "This might be a great space to expand your downtown coffee shop into. You could join me as an investor in the building," Steve explained. Larry was intrigued by the possibilities and said he'd like to think about it. Steve then asked, "Can you check to see if the town would allow this type of mixed-use development on the site? I don't know as much about the zoning process as you do." Larry agreed, and they left the restaurant with their intent to meet again next month. Before the next Planning Commission meeting, during which the White Manufacturing zoning request would be heard, Larry approached the town's AICP planner, Bob, who was there to present the staff report at the meeting. He asked Bob about the zoning and development requirements for the White Manufacturing site if the property were to be rezoned. At the end of their conversation, Larry explained, "I'm already thinking of relocating my coffee shop to the site if the rezoning gets approved tonight and Steve renovates that old brick factory building like he intends to. I talked with Steve and he thinks it might be a good fit for the site and we could be investors together for the redevelopment." As Larry was talking to the town planner, Mary, the chairperson of the Planning Commission, was nearby reviewing her agenda packet for the meeting and heard the whole conversation. The meeting was getting ready to start shortly, and Larry left to go get seated. Mary and Bob looked at each other as if they knew something was not quite right. They both got ready to start the meeting as dozens of residents poured in for the rezoning request, which had received a lot of recent media attention. Now let's address some key questions. Are there any potential ethical violations in this situation, particularly related to the AICP Code of Ethics? If so, what are they and what should be done about them? Let's look at the role and responsibilities of Larry, Mary, and Bob. Larry, as the planning commissioner, is potentially in conflict with several APA ethical principles. First, as a general rule, Larry is obligated to disclose any real or perceived conflicts of interest. While Larry was meeting with Steve about the White Manufacturing property, they discussed a possible investment in the property together. While Larry did not commit to anything according to the facts, if this remains a distinct possibility, Larry should excuse himself from the rezoning public hearing. Even though the rezoning itself was not part of their conversation, it related to his future business interests he may have in the development if the rezoning is approved. The fact that Steve and Larry are friends does not in and of itself constitute a conflict of interest. However, when they begin to discuss the future of the site, zoning details, and a business partnership, the conversation moved in the realm of a potential personal and financial conflict of interest. It should also be noted here that the ex parte contact, which we have previously covered, is also a relevant issue with Steve providing details on the future plans for the site, including demolition and development possibilities that may be relevant to the request as well. Related to this issue, the American Planning Association Code of Ethics states in part, public officials shall not engage in private communications with planning process participants if the discussions relate to a matter over which the official has authority to make a binding final determination. In addition, it's not an acceptable practice for a public official to vote on issues in which they have a financial interest. The AICP Code of Ethics states in part that work should not be performed if there is a possibility for direct personal or financial gain to the official, family members, or persons living in the household, unless the employer, after full written disclosure from the official, consents in writing to the arrangement. Finally, while Larry may have innocently been talking with the town planner about development options for the site, once the conversation turned to the possibility for his own business interests and the connection to the rezoning that evening, this placed the town planner in a potentially difficult situation. Mixing the public business with the private interests of the planning official is the primary issue here. This relates to the AICP ethical code that states not to use the power of any office to seek or obtain a special advantage that is not a matter of public knowledge or is not in the public interest. Overall, the reasonable thing for Larry to do in this situation is to disclose his personal interest in the development. He should abstain completely from the discussion and leave the room. In terms of Mary, the Planning Commission chairperson, she now knows that Larry probably has a real or perceived conflict of interest regarding the white manufacturing rezoning request on the agenda that evening. She could review the conflict of interest guidelines established for the Planning Commission and ask for disclosures of the Planning Commission members before the hearing begins, particularly if she does not have a chance to talk with Larry before the meeting. Bob, as an AICP planner, has the responsibility to uphold the AICP Code of Ethics. Planners have a responsibility for the entire planning process and a special concern for the long-range consequences of present actions. Bob could have quickly raised the conflict of interest issue with Larry during their discussion and suggest that he remove himself from future discussions about the project. He could also have a short conversation with Mary, advising her to take the lead in clarifying conflict of interest guidelines before the hearing begins on the white manufacturing rezoning. Following this meeting, it might be advisable to set up a professional development training or set aside some time on a future agenda for reviewing the rules, guidelines, and state policies regarding conflict of interest and refined and adopt guidelines locally with assistance from legal counsel.
Chapter 10, Other Planning-Related Codes of Ethics. Some states have adopted principles by their local chapters, a chapter of the American Planning Association, or similar organizations which help guide public officials in how they conduct their local business, particularly for planning and zoning. It's important that you look at these sources as well as guidelines for how you should conduct your business and as it relates to planning and zoning codes of conduct. Two examples from Michigan APA chapter are worth noting. One, impacts of decisions, and two, the advancement of planning knowledge. Sometimes it's important to give special attention to the long-term and short-term impacts of interrelated planning decisions. It's also important to contribute to the advancement of planning knowledge and for the Planning Commissioner to make it a duty to advance and inform the public of key planning concepts and processes.
Examples of other themes found in ethical guidelines for planning officials that may get overlooked from time to time include protection of the natural environment and quality of life. Strive to protect and enhance the natural environment and quality of life through careful and thoughtful decision-making, advice, and recommendations. Use of professional staff. Strive to utilize professional staff and other resources to achieve the most desirable results with regard to the community planning process. Interaction with the public. Continually strive to keep the public informed on community planning issues, encourage communication between citizens and elected and appointed officials, and emphasize friendly, courteous, and professional service to the public.
At the start of this course, we said that we would discuss and review the ethics decision tree, including a number of key concepts, including what does ethics mean? What is a conflict of interest? Potential conflicts or appearance of impropriety, conduct, ethics and fairness, APA ethical principles in planning, and other related ethical guidelines. Chapter 11, Activity. Following scenario. Sally James, a member of the Spartyville Zoning Board of Appeals, is also a member of the Regional Hospital Board of Directors. The hospital has applied for a variance for a provision of the community's zoning ordinance to enable the hospital to develop a facility within the community. A public hearing has scheduled for the ZBA to discuss the application. Because of her experience in the planning and zoning arena, the hospital board has asked Sally to represent the hospital and present its argument to the ZBA at the hearing. Sally is faced with an ethical dilemma. What do you think? Should Sally decline the request and appear before the Zoning Board of Appeals on behalf of the hospital? Should Sally participate in the public hearing as a member of the Board of Directors of the hospital and present the argument in favor of the variance? As such, it would be viewed as a conflict of interest for Sally to participate either in the discussion or the vote on the variance request. At a minimum, it could raise questions about her ability to render a fair decision. Sally's board members know her and know her interests, and it may be difficult for them to distinguish between the decision before them and the impartialness of their decision relative to her position. In consultation with the municipal attorney, the ZBA has already laid out guidelines based on state law, attorneys of general opinion, and local guidelines that help establish the procedures to follow in this instance. In addition, the bylaws outline a code of ethics based on the American Planning Association guidelines and state chapter guidelines, which help guide their decision-making. While the code of ethics is not law, it is a guideline which local officials should use to strive to uphold the highest ethical principles. In conclusion, now you should be able to define ethics, define conflict of interest, identify the relationship between ethics and conflict of interest, identify how ethics affect the duties and responsibilities of planning officials, identify additional legal principles that address ethics, and identify ethical principles of planning. This concludes Course 2 of the Planning Commissioner Training. For more information about Planning Commissioner Training and becoming a Master Citizen Planner, site below.
All right, congratulations on class 2.
And did you write down did you make notes on how to get the sound to work for next time? Can you hear me, Carrie?
Sorry, I couldn't hear you. What did you say?
Did you make notes on how to make the sound work next time?
I did, and actually I had to take my headphone out of the system entirely, which is why I couldn't hear you just now. I had to talk to that. But yeah.
All right. Does anyone have any questions or any points they'd like to make after hearing what we just heard?
It's always good to go through this stuff. It's always got a little bit of stuff to think about. I'm going to withdraw my application for a Burger Barn drive-through on the Laguna Lowlands.
This one was, I'd say this one was very similar to I mean, you have to do that. Is it every other year, that ethics training class?
FPPC, yeah.
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 So that, I think it covered a lot of similar things.
Is it ethical to watch that training and count the minutes till you've done your 2 hours though?
I just did that training. I don't know, because this is my first year and it was very, very similar. But I thought the other training was a little bit more, I thought it was better than this on the ethics more apart. It was really a good training.
Yeah. Well, it's
Yeah,
also specific to California too. These are a little bit more broad. I said this state does this and this state does this. I mean, it is a little bit state by state, it sounds like. So I think the FPPC one is good because it is very obviously specific to California.
Yeah, so a few of the highlights of things that, I mean, the recusal area is required in California. So the 500-foot radius maps that you all have, which if you sort of know it's in your neighborhood, you should be checking to make sure, or if you can't find it, give us a call. We've got them on file. So that you never run into a situation where like, oh, I live next door to this project site. I think one of the other things that I would add to some of the things they said, sometimes like the comment where some people got a communication. If you ever get a communication from somebody, definitely forward it to staff. We will make sure it's posted on the website, included in the staff report, and available to the commissioner. So we'll kind of do the job to make sure, that is part of our job, is to make sure that all of those communications are fair and public. And so we do, there's some easy resolutions to some of those things that they kind of posed as problems in this.
I wanted to talk just a bit, they talked about the ex-parte communication, and I know that we are sometimes asked by either applicants or opponents to things to meet or discuss or whatever. And I, in the Huntley Square, I did meet with the neighbors. And I did talk with Carrie, I think beforehand about it. And I did disclose at the meeting that I did. And I wonder if it's something that, and when I met with them, I just really listened. I didn't really say anything. There wasn't really even a discussion. They just kind of downloaded on me. And I just, I knew it was going to be a big issue. And so I wanted to sort of, make sure that they had the chance to get heard. Because, 3 minutes in a public hearing is not always very much time. But I wonder if there's, should we be doing that, or should we sort of prohibit things like that from happening? I mean, do we have anything? I don't know that we have anything, at least that I've seen, that's written down specifically about that. I don't know if other commissioners or Carrie, you have an opinion about that.
Well, I can say we don't have anything specific about it. If you've ever talked to me, I certainly have given you the guidance of if you don't feel comfortable with it, don't do it. If you do it, disclose it, and never offer an opinion. It should be because there will be situations like they showed in the video where someone approaches you and starts to talk to you, and you can politely say, I want to keep all the communication for the public forum, but there's no law in California that says you can't engage and listen to them. You can't offer opinions or prejudge or put yourself in a position where you're offering an opinion or anything like that. That is because you're quasi-judicial in your role as a planning commissioner, all of that. Like just like a judge, you're hearing the case, the first time. You may know about it in the paper or something, but then that's where, just closing, like as you did, Chair Fritz, that, hey, I went and listened to the neighbors and met with them on site.
Sorry, Carrie, it was my understanding, though, that you can't have information that isn't disclosed to the whole commission and the public on any issue. So if, you're listening and they give you information that is not disclosed, that wouldn't be appropriate. That was my understanding from.
Yeah, and I don't think, information and opinions about their feelings about something is a little bit different. Like if they had information like, hey, there's a tiger salamander, on the side or something, that would be information that is something that is relevant to the regulations regarding the case. But frankly, I mean, I've never been a commissioner or anything like that. But yeah, the safest route is definitely to just not engage and say, submit your public comments. And I'll shut up because I see other commissioners have some thoughts as well.
Yeah, go ahead, Everett.
Yeah, I was just wondering, like when we go do a site visit, I mean, is that kind of getting information different than what's presented? How does that come to play?
I would say that's part of your due diligence.
Yeah, I think it's, that's sort of, you're just familiarizing yourself with the site and and not just the specific site, but the surrounding uses. And I think, my opinion is, as a planning commissioner, I want to understand the impact on obviously the adjoining sites and intersections and traffic and that kind of thing. And so I think I think it's reasonable to go to a site and gather that information for yourself so you have a fuller picture, because you can't get that from just looking at a site plan that's presented in a staff report.
Yeah, you just got to be careful, I guess, if you're doing a site visit and someone is there to talk, so kind of similar thing where you should really, I guess, comment or just listen.
Yeah,
and you certainly can feel free to say, I am a sitting commissioner. I need to, I want to hear all of the comments within the context of the public meeting, so it's open and available to everybody.
Yeah,
I think with regard to meeting a client, an applicant, a couple of things come to mind. One is obviously we have to be very careful not to offer any kind of opinion, and in fact to almost do the opposite by saying, I'm not going to tell you whether I agree or disagree with anything you have to say until I've heard all points of view. And then the other thing I think is be aware, if you are invited to participate, make absolutely sure that invitation is being extended in the same way to all the commissioners, simply because I think what can happen is if an applicant knows perhaps one commissioner, or whether it's on the planning or another body, is somewhat sympathetic to their type of development, shall we say, they might be tempted to ask that commissioner to come and take a look, and knowing that it's going to tug at the heartstrings or whatever the professional heartstrings. And I think I can think of some examples of that. So I think making sure that you remind, that we know that the invitation has been made to everybody in the same way. But I think if you do those things, then I think there's nothing wrong with it.
Deborah?
I was going to say also 3 minutes is not a lot of time for public comment, but what I did when I went to visit the site at Huntley and neighbors came to me, I was like, I so appreciate this is really a very, moving situation for you. Feel free to write a letter to care, of public comment, because you can be as long as you want. We'll all read it and be able to see it all at the same time, take it into consideration. And then you can have your 3 minutes at the public, comments. So I think I just reminded people that they could write a letter if they had more that they wanted to say, because, sometimes opinions are adding information that should be available to everyone, should be public forum. So it's a slippery slope. I think, reminding them they can write a letter and
And that's exactly what we as staff tell them is too, that, we do let them know that it's the 3 minutes, but if they have longer thoughts, they're welcome to do public comment in writing.
Just one other brief thought. I think this training touched on it a little in one passage. Talked about the board acting as a body rather than as a individually. I remember a little while ago, there was, I think it was a design review. I made a decision, voted on it, and then one of the members of the board appealed the decision it had just made, which to me is extremely questionable, because if they had that strong an opinion, they should have recused themselves before the hearing to preserve that, I would say, right, because of course anybody has the right to appeal a decision. But I think for me, I've learned I don't always agree with the decisions of the boards I've been on or the planning commission. And if someone asked me personally, I may share that. Yes, I didn't agree with that decision, but I would never be critical of the decision. The decision is made, and if it's made with the ethical standards that outlined and discussed, then I think the decision is sound. And it doesn't matter if we're not a consensus body. We don't need to be. We need to be respectful of the process and know that the majority on a split decision, majority rules, and that's the decision of the board. So I think that's, for me, an ethical, a sort of ethical place we have to be on the commission, and it helps us respect each other and respect our differences of opinion as well, because we'll inevitably have them.
Thanks for that, Zach. I agree. I thought that was a strange move when that happened. And actually, I know that's happened on the planning commission too, when a planning commissioner has appealed a decision of the body, and it always seems a little bit like, I don't know. You've had her choice. It's almost like the double voting, voting.
Exactly.
Deborah.
I just want to make sure I understand what you're saying. This was not the planning commission. It was another entity, and they made a decision, and then one of the members appealed it. Is that what you're saying?
Yes.
So how do you, well, I guess it doesn't matter. Okay. Thank you. Yeah, I agree. I mean, I think part of being on any board is knowing that things are going to get passed that you don't necessarily agree with, but if the process is,
Yeah.
Yeah, so we don't have anything in our planning commission resolution that says that you can't do that. I don't know if there are places that do. I know it's an infrequent thing, and I hadn't run into it until I came here. And I had to consult Larry, the city attorney, and said, what do I do about this? And, his response is, well, as commissioners, you don't lose your right to, as a private citizen. So it is allowed in that way. And it's infrequent, but it has happened.
Everett?
Yeah, I think one thing I always think about when the other trainings is the appearance of a conflict, and everything could be legal and proper and so forth, but if there's an appearance, that's something you need to be careful regardless of what board you're serving on.
Yeah, it's true.
That's true. And that's where I think, if you are in Rotary or something with somebody, or you served on a Rotary board with them, say, or something, it's up to you to be able to understand if you can be unbiased, if there's no actual conflict, right? It's can you be, the question you need to ask yourself is, can I be unbiased or not in the weighing of this decision? And if you can't, obviously, just because, and I have had people who recuse themselves for a non-financial, actual conflict issue, and just say, I don't feel comfortable with this. But if you do, then you can, and I've had commissioners say, hey, yeah, I, play tennis with this person, right? Whatever it is. However, our kids were best friends in school. However, I feel I can be unbiased in this. And you can actually do that in the statement of conflict of interest section of a meeting agenda, or at the beginning of the item. Usually you don't want to let me or the chair know at the beginning of the item, but the statement of conflict of interest, you can certainly, that is the time that you can and if there's an appearance, then you're basically telling the public, yeah, I know that I served on this board with this person. However, it's not going to affect us.
Well, it's just like the if you're talking on an item that's within a certain radius of your house, that is something that's written in. And so you're not, maybe you can be biased or not, but that's one example there that says, okay, regardless, if it's within a period of so much, then you can't
Right.
on there.
Right.
So.
And some of you will know, I actually had to recuse myself from a variance that was within 500 feet of my house. So even as a staff person, I didn't deal with it. I didn't deal with it. It was a contract planner, and I had her supervisor, who's a planning manager for Petaluma, review the report, so that I had nothing to do with that, even though the reality is it's, the direction of the 500 feet is that it wouldn't have affected me at all.
Right.
Well, fortunately, I guess as an architect, I haven't had any issue come before this commission, but obviously as an architect, I go in front of other boards and commissions, and I've had potential things that were going to come up and then ended up not happening, but it puts me kind of, obviously it's my project. I have it's me as my firm. I have one other part-time person, but not really at the level that she could do a presentation. So I would potentially have to, I'm not sure what, hire someone else to do a presentation of my project for me and recuse myself, I guess.
Yeah, that is how other people have handled it. And I have had because there are some regulations. So I have had a planning commissioner who was an architect design his own house and decide to go through design review, which was with the planning commission, while he was sitting, and it was extremely difficult for everybody involved. Staff, the planner who was working on it, found it extremely difficult. That wasn't me, but I felt for her. The other commissioners actually held him to a much higher standard because of all the concerns, and and his interactions with his neighbors were severely compromised because of it. So that is, even though you technically can do some things, and I'd been the director at that time, I would have advised him to have someone else handle the presentation and just not be there in the room at all.
Anything else about this specific training? Gary, I had a question. You sent us those documents after the last session, and I thought you said you sent us the Planning Commission resolution, the Planning Commission ordinance, and that Planning Commissioner's handbook, and then the Brown Act thing. But I didn't see the ordinance.
Oh, I think I had sent No, the ordinance is actually on our Muni page. I didn't send it. I may not have sent it. You all have it from the past when we talked about the geography and everything. I think we included the whole, but that is on our website in the Muni code. It's like, I think it's section 2 point something under administration and personnel. So that's available on the website.
Okay. And I just noticed something unusual on the Planning Commission resolution that Claire and Najarian both voted aye and was absent at the same time. Anyway, not sure how that happened, but well, great. Well, if no one else has anything else on that, do we have any subcommittee updates? Everett?
Yeah, Kathy and I had met just to kind of review what we are regarding Ex-Park, and we had kind of a list of things that we were thinking kind of low-hanging fruit. But if we discussed that if we're going to be looking at the master plan for the park, some of those things may not make sense to move forward with. Painting a lamppost. Well, is that lamppost going to be there? And how much longer, or how long does it take us to do the master plan?
Mm-hmm.
One thing is I had the president of the Little League had reached out to me after our last meeting and just kind of touch base and, basically, saying hope that he wasn't offensive or, what he was trying to say, and which he wasn't. And so we exchanged a few emails and I ended up actually meeting with him. He's going to be, I guess, coming to do a report. He's not asking for any votes or anything. He's just simply doing a report on March 8th. And we had a really good meeting. We talked about the Little League, kind of, and he really opened up as far as some suggestions of how we might be able to use, or people might be able to use the field for events. Maybe people could put blankets there and, have more crowd capacity there. He talked about he thought about taking down some of the signs on the fence, which we had done before, which were good. I mentioned to him also that both the ball field and, say, for example, the Annalee Gym, there's no Sebastopol logo. There's no, there's people coming to visit, and it just seems like the city should have something there to say, hey, come, go to this site and to find out, what food areas are around, restaurants and so forth. So those are kind of some of the things we talked about. I had also mentioned, I think to some of you, Carrie, I think I did, that I felt that it would be a good idea to maybe have a representative from the Little League be on either our subcommittee or certainly part of the master plan update. And so that they can report back. And I think it just would foster a good working relationship for that. So I'm not sure what the rest of the commissioners' feelings, whether that should be a subcommittee or just another, but I think that's something that will happen. The president also suggested that when they do their annual reports, to do it in October, because that's when they have a changeover of officers, and they have a report at that point that they present to the board. So that would be a good time to do that. He also indicated, as the lease had said, that financial reports should be made to the city, and I don't believe those have been made in the past. So that's just one thing that was just kind of brought up. I didn't really make a comment on it, but I think it's something we might want to take a look at. So, basically, it's if we are the park commission as well, I just felt that we should have that kind of information presented to us, or at least know about it in some of those questions. So hopefully this will get us back on a better track.
Thanks, Everett.
Thank you, Everett. And yes, I did talk to Andy about coming on the March 8th and at your next meeting.
Yeah.
Great. Any questions about that for anyone? I was just gonna say, I think it might be worth, Everett, if you have this, your low-hanging fruit list, if maybe, we can bring it back to the commission at some point and talk about, maybe there are, if you want more feedback on things that we might want to move forward with. I mean, I still think we're probably a ways off from, a whole new master plan and funding for it and rebuilding Ives Park. So we may want to, there's still maybe some things on the list that are worth doing, because it's going to be 5 years or whatever before anything happens. So if you want to bring that back to the commission at some point and have a broader conversation, I think that'd be a good idea.
I think it's a good idea, and then we can get comments from that standpoint. And as far as the master plan review, based on the last council meeting, Carrie, do you know what would be the next process for that, or where do we go from there?
Sure. So the Color Creek component of it is funded, and so Jessica is moving forward with the preferred design, option B. And GHD is moving forward with the hydrology work study to make sure that it's feasible and help with the design and engineering part of it. That has been funded. In terms of any updates to the master plan itself, those are not funded, and that's not something that staff can take on itself. It's a pretty major project. So we will need to look at scheduling that. When that happens, and I don't know if that's next year or the year after when that happens. I did have a meeting, this is a little off topic, but just in terms of the budget process, which has started. We haven't gotten a lot of impact fees for the park fund in this last year. We do get the Measure M funding from the Parks for All, Measure M Sonoma County tax funding, and that's actually a little bit higher than anticipated. It'll be about 100,000 instead of about 85,000. But looking at the improvements for that, staff is recommending that be used for there's any cost overruns which we're anticipating due to inflation for the AmeriCorps Trail, as well as Ives Park pathway components of it. And I'm meeting with Jessica in Public Works to make sure that we're the parts that don't make sense to build anew but need to be maintained, that we maybe use Measure M dollars for that, because that's one of the few funds for maintenance as opposed to new stuff. And then we can still use the Prop 68 that's been approved for the new pathway sections that aren't going to be, wouldn't need to be rejiggered in the master plan. So I did not include, I've not thought about including any funding for the master plan in this next fiscal year. I think from a staff perspective, we have the housing element and a couple other, and the Calder Creek and the Climate Action Framework and a few other major projects to get through before tackling the master plan. But I do see that as being, yes, the next step of, okay, if here's the creek, we know the ball fields are here, how do the rest of the elements play out?
Yeah. All right.
And it sounds like from the way it was done last time that there may be a little bit more public participation and community, workshop of that than there was in the past.
All right. Any other subcommittee updating?
I can just tell you really quickly that the Climate Action Committee, it has 2 compost giveaways scheduled. So if you want the information on that, spread the word. That's really exciting. And we're moving ahead with the art project we've been working on. And Phoebe's been doing a great job building the framework. So a lot of little moving pieces there, but I think that's the most important for right now.
Thanks. All right, if there's nothing else on subcommittees, you have anything to report, Carrie?
Not a whole lot. Let's see, the Ives Park Sculpture Garden has released a second call for artists for additional sculptures for that. So that is out on the website. And so if you know of any artists, definitely get it out to them. The Design Review Board at their last meeting approved 2 more facade improvement grants. So that program is actually gaining some momentum. I think we've had a couple of applications each round, which is great, and that's generating quite a bit of interest. The City Council last Tuesday did discuss the 3 public parklets, and they did vote to renew the temporary parklet, request an extension of that, which would be a 1-year extension. But also asked the Planning Commission for their input. And so in terms of any potential permanent parklets. And so I've been working with engineering and I was talking with them today and got the full update from them since I wasn't at that meeting. That is something that isn't funded and isn't staffed. So we're looking at I've asked GHD, which is our engineering consulting firm, to put together a proposal for what that would cost, because obviously there's getting that through the process, which the city engineer right now does not have capacity to do. So that will be coming to you at some point. And Paul, I know you wanted that to be sooner rather than later, but the temporary parklets have been, I mean, my understanding is that council did say, yes, go ahead and extend them on a temporary basis.
Yeah, I mean, I was at the meeting and they did say that. They said that they were okay with the one in front of Retrograde and Sunshine Cafe becoming permanent. But they were not certain they wanted the one at intersection of Petaluma and Sebastopol, or the one in front of People's Music to stay. And to be perfectly honest, they said they wanted the planning commission to review it. I wasn't exactly sure what they wanted the planning commission to review, or what, if the planning commission is decide. I don't know if you got further direction. It was not clear to me what they really wanted from us.
Yeah. So, and I was like, well, you're not asking the planning commission to design this thing, are you? Because that doesn't make sense. No. What I discussed with the city engineer today is that, there's a lot of requirements that Caltrans has. And then there's, what design parameters would the planning commission, as the Parks Commission, want to see? There's the issue of the capital construction cost, as well as the maintenance costs that would need to be approved by council. Because there are, it does take time and whatnot to make sure they look nice, as well as are maintained in terms of the garbage and cleaning and that kind of thing.
I'm a little bit confused about this whole thing, to be perfectly honest, because I feel like we're making it more complicated than it needs to be. In that, and years ago, the city is, before your time here, Carrie, the city came up with a process for parklets, because we had this event and we wanted to do parklets, and so the city came up with, here's a process for, if you want to do a parklet, this is the process. And part of the process, if you're on Main Street, is that you have to get Caltrans approval as well. I mean, I think it's great if the city wants to be a partner in this. I don't know that the city, traditionally parklets are a business sponsored thing. I mean, that's how they started. It was a business wanted to do parklet. You submit an application to the city. It's a design review process, and this whole process that goes along with it. But it wasn't the city making a parklet.
Here's the problem, Paul, is that a business cannot use a parklet as you cannot use the public right of way for a business use.
Well, I understand that. So Caltrans is a whole different issue, different from a private or a city street. And I know the city has to be the applicant, but I guess, anyway, we can talk about this offline. I don't want this to get so complicated and bogged down in bureaucracy that nothing happens, because I can see that happening. So I don't know what the best way to kind of move that ahead, but I'm just fearful of that. And I know there is bureaucracy involved, but I don't want to overcomplicate it, I guess. Everett, you had your hand up.
Yeah, just question. So the barriers, who owns those barriers? Is the city?
The city bought the barriers.
Okay. And yeah, one thing is just to keep an open mind as far as maybe repurposing, if it's possible, like we talked about Jewel Avenue, trying that out, or if they can be used somewhere else that maybe would make more sense, rather than just store them somewhere, or I'm not sure what's going to happen to them, but I think it's, if they're there and we went to that, it might be an opportunity somewhere else.
Yeah, for sure. Deborah?
I will probably have to, I do have a conflict of interest because my business is right in front of one of the parklets. And, but I would like to say that, being downtown, being a business owner, I think that there's a lot to take into consideration. So if they're going to give this back to the commission, we really need to look at all aspects of this. This has been such a difficult time for businesses that if it is, giving anybody money or helping them stay in business, we obviously want to lift them up. But if it's taking away parking or obstructing business or causing other issues with the unhoused or drug deals, I mean, there's so much going on with these parklets. I just don't know who's the right. I'm just saying it's complicated. I don't know how we're going to how we're going to handle this or what they want from us. And I can give you my, as a public comment, but obviously not as a commissioner. So there's a lot. It's a lot. You'd have to be downtown daily to like kind of grapple the whole situation. But it's been a blessing for some businesses for sure.
Okay. Anything else to report on your end, Carrie?
There is a special city council meeting tomorrow. I believe they're scheduled to discuss the RV permit parking system, as well as board and commission vacancies, and give direction to staff on those. The planning commission ordinance did get bumped to a future date, but the planning commission vacancies are, I believe, are part of the staff report for tomorrow now, so that can move forward.
All right. Any questions of the planning director's report?
Actually, just to verify, representative and alternates for tomorrow.
So I don't need anyone for tomorrow night. It's actually the city clerk's agenda item. The Huntley Square, sorry, thank you. That actually reminds me, March 1st. We'll have Huntley Square as well. Hearing that was postponed to that date certain of March 1st, and the housing a workshop with Four Leaf, the housing element workshop with the city council. That's a follow-on from the December 14th discussion with the commission. And I believe Chair Fritz is the liaison for that and has confirmed that he will be attending.
Yes. So both those items are next week?
March 1st, yes. That is next Tuesday, yeah.
Okay. Yes, I will be there.
Great.
All right. No other questions or comments? Thanks for showing up again, Zach, taking the training, even though you're leaving us. Hopefully it's useful in some other way. So I will adjourn this meeting then until March 8th. Have a good rest of your evening, everyone.
Thank you. And we will have a meeting on March 8th. I think we'll actually have 3 items, although I think one of them will be pretty quick.
Sounds good. Thanks.
Thank you so much. Bye.
Bye.
All right. Good night.